So hello everybody, thank you for joining us again. The topic of today is to talk about maintaining your green card. It could be that you're on a full green card, it could be that you're on a conditional green card, but what is it that you need to do as a green card holder in order to maintain your residency and to meet other US requirements? So we're very lucky to have with us one of my oldest EB-5 clients and also an expert in Indian and US taxation, Mr. Narasimha Malti. Mr. Malti has been through the entire EB-5 process himself to the point of return of capital. So Malti, why don't you introduce yourself?
Hi, good evening to everyone. My name is Narsim Murthy. I applied for EB-5 in the year 2014 and I got somewhere in 2015 my EB-5 is approved, and ever since 2016 I'm living in US and India. I shuttle between India and US because of my profession. I practice as a chartered accountant in India and also as a CPA in US. So I handled taxation in both the jurisdictions. And my investment is almost ready to come. I haven't taken, because of this COVID, it got delayed a bit. Otherwise, my money is ready to come back anytime now.
But you have both your I-526 and I-829 approvals, right? Or you filed the I-829?
I-829 is pending, but I-526 got it long back. And
Right.
829 is pending for approval.
Gotcha. Okay, so Gary, perhaps you could introduce yourself, though you're a regular speaker, so you're known to some, I'm sure.
Well, thank you, Mark. It's a pleasure to be here. My name is Gary Kaufman. I'm a United States tax lawyer for over 25 years. I work closely with Mark's clients, applicants from around the world for an EB-5 visa, green card, or it could be an L1 or whatever the visas are. And what I do is I provide the United States Tax Council tax structuring advice, both from a personal income tax standpoint and also from a business income tax standpoint, and also from a transfer tax standpoint. How to structure your move to the United States in a tax efficient way to minimize United States income tax and to comply with all the tax reporting requirements. I also advise if you want to set up business operations in the US, if you already have operations overseas, how to structure US operations within the context of your global operations in a tax efficient manner. And thirdly, I advise for family succession tax planning once you're in the United States and domiciled here.
Great. So, you know, these events are always better to the extent as we go along, if people can ask questions, because if you have a question, you know, other attendees almost certainly have the same question. So, you know, I'm bringing up the Q&A screen. If you have any questions, please ask them, and, you know, we'll answer them as we go along. Well, the first thing to talk about, I think, is, you know, what is it when you've got that conditional green card? We'll talk about a few things. One is going to be transitioning that conditional green card to a full green card, the processes involved, why there are delays. If there's anyone who wants to ask about if your I-526 is approved and you're waiting for the actual conditional green card, we can answer that too. So that'll be part of the discussion. Then we can also talk about the things you need to do to maintain your residency. And then, of course, with these two gentlemen on the line, tax is going to figure heavily in our conversation, because remember, you do have to file a tax return in the US. And, you know, let's talk also, Gary and Malti, about state tax returns. We have a client who thought that he didn't have to file a state tax return. So we can talk about that. Let's start out by just talking about some basic things. If you have any kind of green card, whether it's conditional or whether it's full, you're supposed to be fully resident in the United States. So Malti, I know that sort of during the period of your residency, you had a business in India and you were traveling between the United States and India. So what steps did you take to make sure you were maintaining your green card and your US residency status whilst traveling between a business in India and the United States?
Okay, thanks, Mark. So I have my practice in India and I do have my practice in US. So as far as my India practice goes, so in India,
I'm going to interrupt you because a question just came in that's relevant. Let me read the question and then I'll let you continue. The question
Sure.
is, I wish to know how to maintain residency while family, wife and kids stay in the US and I work in another country. That sounds like just what you did. Can I keep coming to the US and maintain my conditional green card? So I just wanted to read that question quickly because it seems to be very relevant to what you're about to talk about.
No, you finished, Mark?
Yep. I just wanted to read the question, Malti, that's all.
Yes, there are two pieces to this question. One is a tax issue. The other one is maintenance of your green card, which Mark is going to address, like how you can maintain by being outside in US for the purpose of your tax residence, for the purpose of your green card. As far as the tax residence goes, in my personal case, I was a resident in US because of my green card holding, regardless of my stay in US. Whether I stayed for 6 months, I stayed less than 6 months, more than 6 months, I had a tax residency in US as a resident. Similar with India, India follows a different rule as far as the tax residency goes. For you to become resident in India, you have to stay in India for more than 182 days. And sometimes I did and sometimes I didn't do. That's when you have to look at a double taxation avoidance agreement. And based on the double taxation avoidance agreement, you can take the residence based on an economic interest in India. So regardless of my stay in India, whether it was 182 days or less than 182 days, I took a residency as tax resident in India because of my economic interest, largely owing to my practice in the initial years. Now that the economic interest is equally divided, I go by my residence in US. As far as the US is concerned, I continue to be resident, tax resident. And when it comes to India, it depends on my number of days stay. So generally, I maintained 6 months here, 6 months there. So I never had any issue with my tax residence as far as India goes. But as far as US goes, regardless of my stay, I always declared myself as a tax resident. I hope this question answers.
A simple question a lot of clients ask, Malti, is, does that mean you have to pay taxes on the same dollar or the same rupee, both in India and the United States?
Okay, that's a good question. So essentially, in US, you pay tax on every income you earn in the globe. In other words, it's a global income is liable for tax in US. That is simply because you are a green card holder. But as far as our India goes, it depends on 2-3 things. Like if I become a resident in India, then again the global income will be taxed in India. And if you are a resident but not ordinarily resident, there are 3 things that happens in India. One is resident, then the resident but not ordinarily resident, then non-resident. So if you are a non-resident, then you don't pay tax on global income. But if a resident or ordinarily resident, then definitely you will pay tax on global income. So in my case, what happens, fortunately for me, you get what is known as a foreign tax credit. So I don't end up paying too much of tax because whatever tax I pay in one country, I get a credit for that in the other country. Like for example, my India income, if I'm offering it to tax in US, then whatever taxes I paid in India, I can claim it as a foreign tax credit in US. So my tax is reduced to that extent.
Right. So key point is, if you have a conditional green card, you must file taxes. So we had a client recently who, I won't name the country so no one can guess who he is, but he's an Indian guy who lives somewhere else in the world. He thought that he could file a US tax return, Malti, with a foreign address, claimed to be a non-resident. So obviously you can't do that. So you had a US address at all times, right?
Yes, all the time I had a US address.
So you must be filing your US taxes with a US address. You can't say you're not resident. As soon as you say that, they'll take your green card away.
That's true. That's true.
So let me ask Gary. Gary, if I have a US address on my federal return, I realize that you're not an expert in state taxation, but what are my obligations sort of for filing and paying state tax returns?
Well, what's very important for an individual who's applying for EB-5 and coming to the United States to realize is that within the United States, which is an extremely sophisticated tax jurisdiction, there are several levels of government, and each one has their own tax jurisdiction and their own tax rules. The first one is the national government, the federal government, administered by the Internal Revenue Service, or the IRS. That's what we've been speaking about up till now. So you'll be required, once you become a resident or as a non-resident, on certain circumstances, you file United States tax returns if you're a resident on your worldwide income. But separate and apart from that, we have 50 states in the United States. And depending on the state that you reside in, the tax rules for personal income tax and business income tax differ from state to state. So if you happen to pick a jurisdiction, a state, in which there's no personal income tax, then the sole tax filings you have to do during the year is to the national government, to file your federal income tax returns. However, aside from about these 6 or 7 states, most states do have a personal income tax. So then the question is, just as we do the analysis federally, are you a tax resident or are you a non-resident of the United States federally? You have to look to the rules of the individual state where you live in and determine, are you a non-resident of the state or are you a resident of the state? And that'll determine what your tax filings are with respect to that particular state, wholly independent of whether you're a resident. You can be a resident, for federal purposes, or a non-resident of a particular state, for income tax purposes. It depends on the facts.
Okay, thanks. So there's a question, Gary. If you leave the US on a re-entry permit, which theoretically allows you to be outside the country for a year, we can talk about, we've had people come to our firm who've been advised that they can use a re-entry permit, which is issued by USCIS, only to have the people at the airport, CBP, deny them entry. So I always recommend that clients who get their green card don't immediately get a re-entry permit. And if you don't believe me, I can connect you with people who have been told they can do that by their lawyer, only to be refused entry by CBP. So be careful with re-entry permits. But suppose I have a re-entry permit, Gary, and what address do I have for my tax return purposes?
Well, the important thing to realize here is that, just as we said, the states are independent of the federal, tax law is independent of immigration law. The two are, brother and sister, they work hand in hand, but whatever the immigration laws are, irrespective of that, you have certain rules. What makes you a resident of the United States or a non-resident of the United States? Are you a green card holder, provisional or full-blown? Are you a United States citizen? Or are you present in the United States, under certain weighted average formulas, a certain amount, which would make you a tax resident even if you don't have a green card? So we really would have to look at your facts and then see where you are a resident, and that'll determine which U.S. income tax return are you filing, the non-resident return? Are you filing a resident income tax return? And then you'll put down, the actual address where you reside.
Right. So let's suppose that I had an address in state of Georgia, just to make a supposition. Now I get a re-entry permit, leave the country for a year, star, that needs to be discussed as a strategy. But suppose I do that and I go to Singapore. So I'm in Singapore for over a year. And let's assume it doesn't cause an immigration problem, but I'm still a green card holder, so I still have to file a tax. And I don't really want to use the foreign address. So what address do I put on my tax return?
Well, the important thing, as you pointed out, is that the mere fact that you're a green card holder automatically makes you a tax resident, even if you spend 365 days physically present outside the United States. And as Marty explained, every single dollar of income, no matter, even if you earned it on the moon, you have to report it on your income tax return. So technically speaking, given that, you can actually put down your actual address in Singapore as your actual address on your income tax return, and won't have any effect on your obligation to report as a tax resident.
Right, but if I want to have a US address, don't you have to nominate a state How does that work, Gary?
Well, the thing is that if you have to look at the residency rules of each state on its own, and many states, in order to be a tax resident as opposed to a non-resident of that state for income tax purposes for the year, you have to be physically present in that state for X number of days during the year. Let's say more than 6 months, right? So if you were present in Georgia that particular year, you're in Singapore the whole year, so you're in Georgia less than 6 months, you'd have to see if there are other requirements. Maybe if you maintain a permanent place of abode, even while you're abroad, that'll give you a nexus to Georgia.
So I think what you're saying sounds like to me as though there can't be a generic answer to this question. We need to talk to each individual client about where their US address was, about their circumstances, where they're planning to go, look at the tax treaties and look at the state tax rules and to render proper advice. Is that what you're saying?
Yeah, that's a very important point Mark is making, because it's not one size fits all. And you have to be very, very careful that you put down the answer that fits your facts and circumstances, because if it doesn't, you're going to have communication from the taxing authorities that could go back and forth for quite some time. You're going to have to hire a tax advisor, and they're going to think that you're a resident, and therefore you're subject to this for taxes for that year, when in fact you're not. So you really have to judge it on the facts of each case.
So let's give Malti this question. Malti, staying outside the US, are we supposed to file taxes while an I-526 is pending approval? So let's assume that there's no other contact with the US, right? Because there can be trigger rules, and Gary and Malti can explain all the intricacies of that. But for the sake of simplicity, let's assume there's no business in the US, there's no other contact with the US. If I'm residing outside the US, I've never had residency in the US, am I required to file taxes while the I-526 is pending approval? Malti.
Okay, thanks, Mark. It has two sides to that, two pieces to that. Generally, the answer is no. You're not required to file the return. But I would advise everyone to file the returns, because generally when they make an investment, any enterprise, let's say you are investing at any regional center, they generally have partnerships set up, and those partnerships give K1. And if they give K1, and there is always a withholding tax that is done by these firms whenever they give the dividend, interest, whatever is on the investment which you make. And that withheld tax can be taken as a refund by filing taxes. If you don't file, you don't get those taxes back. So it makes sense for you to file a tax return and get these refunds. So that case, you'll have to, the question would come whether you would file as a resident or a non-resident. Definitely it is a non-resident. You are not a resident because you have no contact with US, you are not come, you are not even got your green card, it is pending approval. So with all these things, it becomes non-resident. So generally you file 1040 NR and you get those monies back.
Gotcha. Just looking at some of these other questions, I think it might be helpful to know. I mean, I realize that every year for you has been different, but sort of how much time have you generally spent in Bangalore versus US each year?
Each year?
Yeah, roughly, just roughly, because people are asking questions about how much time you need to spend in US, and I can answer that question technically, but I think a practical example is always helpful too.
Okay. I think in my case, I have spent, my endeavor is to spend 6 months here, 6 months there. But if I look back, then I would have spent probably 7-8 months in India and 4 months in US for 1 year, and vice versa. In the last 2 years, I have spent a lot of time in US and very less time in India. Probably if I take last 2 years history, I must have spent about 6 months, both years put together, 6 months. That means 3 months each year average, and rest of the 18 months here in US.
Right. I find one of the big lies told is that you must spend 6 months each year in the US. We've done now hundreds of cases over almost a decade. Many of our clients have not spent 6 months in the US. No one has had a problem with their I-829. No one has had a problem with naturalization. So, maintaining residency in the US doesn't mean, as Malti just said, it doesn't mean spending 6 solid months each year in the US. What we always recommend is don't be outside the US for a period exceeding 6 months, because it's a trigger when you try to re-enter the country. Let's see, what other questions do we have that's related to this? Malti, this is definitely a question for you. Can an Indian person or a person of Indian origin inherit agricultural land with any kind of green card or citizenship?
Oh, the answer is, again, it has got two pieces to that. There are certain state laws, there are federal law, we call it central government in India. So the state laws do allow sometimes and state laws do prohibit sometimes. But as far as the federal law goes, in India, you cannot inherit agricultural land. No, that's not allowed. Of course, you can inherit with the permission of the RBI. You'll have to apply for a permission and then take it. But generally, the RBI denies such permissions. I haven't seen that permissions come that easily, but I have seen many instances where they have given permission also to inherit with a condition saying that you must dispose it off within 3 years, 2 years. Some timelines they have put, some conditions they have put. But otherwise, by law, you are not supposed to inherit agricultural land in India. And if there is additionally the state prohibits, then again, like I know some of the states like Maharashtra prohibits, Uttar Pradesh, I may be wrong, I may not be up to date on those states, but it was there in Karnataka, but the Karnataka removed about 6 or 7 months before they removed the restrictions. So in Karnataka, state doesn't prohibit you to inherit agricultural land, while the central law, that is the FEMA, still prohibits you to acquire any agricultural land.
And what if I'm an OCI?
It doesn't matter. It doesn't matter. OCI doesn't change the situation. It depends whether you are a resident or non-resident.
Okay.
So once you are a non-resident, you cannot.
Gary, one for you. Do gains on foreign pension plans, e.g. UK pension, get taxed in the US? If so, are they subject to the usual capital gains stroke dividend tax rules? So perhaps you could answer that question, and then perhaps you can talk about capital gains and dividends and how to plan for capital gains.
Well, okay, just in general, you know, you have ordinary income and then you have capital gains. Capital gains is income generated from investments, you know, from a sale of investments. And the policy has always been to try to spur investment in business and investments in the United States. So Congress has a lower tax rate on sale of assets that would produce a capital gain than the ordinary income rates. Now, for people that are coming in the United States on the EB-5 visa, what I advise my clients, and this is all in very, very general terms, is that there's a window of opportunity for which significant United States tax planning can be done, coterminous with Mark's advice from an immigration law standpoint, that before you trip the wire that makes you income tax resident federally and in a state, while you're a non-resident, we would go over, you would produce an inventory of your global assets, business assets, investment assets, if you own real property, if you invest in startup companies, if you have your own businesses, if you own life insurance, whatever, and then see which ones have built-in gain, unrealized appreciation of assets. Because once you become a tax resident, you know, if you were to sell it then, unless we can come within, you know, certain provisions of the law to get you a reduced rate, you're going to be hit with capital gains tax in the United States, which the rate is higher, I believe, than the Indian rate, you know, on capital gains. So that's one thing. While you're still a non-resident, we could go over your properties to try to minimize or avoid capital gains tax in the United States. There's a whole slew of transactions we could do to try to, if you don't want to sell the property while you're a non-resident, so you're going to sell it when you're a resident, there are transactions we can do to minimize the ultimate gain on the sale once you become a resident. So now also what's important is if you have investments in startups, Indian startups, Singapore startups, there are special rules on that. Once you become a tax resident, capital gains would be hit with adverse tax consequences. So we would look at those assets too. Now, with respect, with respect to the UK pension, there's a double taxation agreement, a treaty, an income tax treaty that the United States has with the United Kingdom. And there's a very important pension article in there. You know, The objective of these double taxation agreements, as Mr. Marty explained before, is that we want to avoid double taxation of the same income. So if you're a resident of the US, taxed on your worldwide income, but you're working in the UK for a UK employer and a UK pension scheme, and you're generating benefits under that, we would have to look at that very carefully on your facts and circumstances, what type of UK pension plan, because there's a superannuation fund in the UK, and if you have certain types of plans that meet certain characteristics and that they're deemed to be similar to, let's say, a 401k plan in the United States, a certain pension plan, you're going to get benefits on deductible contributions. You won't be taxed on the gains until it's distributed, favorable taxation on distribution. So all these are different rules within the treaty, and you have domestic US tax law, but as Mark said before, everything have to carefully review your facts.
Thank you for that, Gary. So,
Mark,
question.
Mark, I would like to supplement on a capital gain, if you permit me.
Yeah, just 1 second. Let me just say something. So if you're asking questions about non-taxation tips for maintaining residency, please stay on the call. We'll address those. We're just going through these taxation issues first. So Marty, please go ahead.
No, as far as the capital gain, I just want to supplement what Mr. Gary said. In India, there is an indexation benefit generally you get, because in India, the tax is neutralized for the inflation that occurs between time when you acquired and when you sell. But in US, there is no such indexation that you get. Generally, your basis gets bumped up if there are some criteria is met. Otherwise, there is a lot of cases where I handled, they claim exemption in India on the capital gains because there are certain exemptions available in India, but those exemptions cannot be claimed in US. You'll end up paying taxes. So you need to be careful on that.
Thank you for that, Marty. So that's taxes in sort of a very brief nutshell. The thing that really alarms me is, I come across clients who we've explained that you're supposed to file tax returns, claiming a US address. As I said, I'll be very careful with these re-entry permits. None of our clients have had a problem, but I've had clients come to our firm who've had real problems with re-entry permits. What you need to make sure is file the tax return. And the adjunct question is, we've really been talking so far about people who are coming to the United States for the first time. So Gary, there's a question on here from a dear friend and client of ours asking, let's suppose that you're doing EB-5 to get your green card or transitioning in another way, but let's suppose you're on a non-immigrant visa. Let's say you're on an E2. On an E2 visa, you could potentially spend as little as 3 months a year in the US and probably set it up so you don't trigger US taxation liability. If you're later going to transition to a green card, are there any special things that need to be borne in mind, any look-back provisions, or just what would your tips be to someone in that status?
Well, Mark raises a very interesting point. A key concept in the tax law is the integrity of the calendar year. In other words, each year stands on its own based on the facts of that year. So we would analyze each year, did you have a green card that year? Were you present in the United States for significant periods of time? If not, your income tax status for that year was a non-resident. The fact that in a subsequent year, you become a green card holder, then prospectively, from the first day of presence in the United States and physical receipt of that green card, from that moment in time onwards, then you're a green card holder, and a tax resident. So you really have to view the facts and circumstances of each year and the period of time up until you get the green card, assuming you're not significantly present in the US on its own.
Right, thanks. So we need to look at that. There was a follow-up on the UK pension question, Gary, and which is this: what if the UK pension has been transferred overseas to a tax-exempt location, for example, Bermuda, and is not currently subject to any taxation?
Well, it's a very interesting question. You see, the thing is, you have to really study the facts, as Maud said before. How many years was the individual working in the UK with that UK pension plan and he accrued benefits, you know, etc. Then on a prospective basis, he was able to transfer it under UK law, presumably, to transfer that to Bermuda. But that's, so you have to view that. But then from a United States tax standpoint, there's no tax treaty between the United States and Bermuda. So the benefits that you had vis-a-vis United States and the United Kingdom in a pension plan under the UK, we'd analyze it under the treaty. If it has approval as, you know, whatever, that is a mirror image of its sister plan. That won't apply in Bermuda. So when you get distributions from the, you know, et cetera, on the plan, or accrued benefits that grow while the plan in Bermuda, while you're still employed, it's going to be based on domestic U.S. tax law, which isn't as favorable as under a treaty. So, you know, you really have to view, as you said before, each year on its own based on the circumstances.
Right. Let's talk about some of the immigration questions. And, you know, at the end of this, we've got a sort of cheat sheet of top tips for maintaining residency. And, you know, if you want a copy of that, then please reach out and you'll have it. I was going to go through some general points, but there's a question here. If a child of a green card holder is studying in college outside the US, in UK or India, could there be an issue, especially for a medical degree, which could be up to 6 years? This is one of the times when for me, the re-entry permit actually fulfills a function. There's a legitimate reason why the person the child in this case, is going to be outside of the United States for an extended period of time. We've had this exact fact pattern. It's not caused a problem. And whilst, you know, I have my sort of caveats about re-entry permits, this is a circumstance where it would be normal and applicable. Always remember as well that you have to look at the age. You want to get that child on the green card, which I assume they are when they hit 21. So it really is a risk if they're over 21 and they put that at risk. So we would want to go through this scenario with the client sort of in great detail, but it can be done, and it's been done by other clients of ours degrees, exactly the same set of circumstances. So hopefully that answers that question. You can, once you become a US permanent resident, or conditional permanent resident, or full permanent resident, you can spend periods of time outside the United States, but it needs to make sense. You're supposed to be a resident of the United States. You're supposed to be saying, this is where I want my home to be. So this is just putting it simplistically. And it makes sense that, you know, if you're choosing to do a course of study abroad, it can be easily explainable that your actual intention is to be resident in the United States. The problem starts to become where someone's got a job abroad. For example, if you have a job abroad and you're not like Mr. Malti, who's traveling backwards, he has a genuine business in India and in America, and he's traveling backwards and forwards. And even though he only spent 4 months in America 1 year, America's still his home, he's not had a problem. No problems with immigration or his application. If, however, you only have a job abroad and all your income is abroad, that's a different set of circumstances which you really need to talk to an immigration lawyer about. This is different. This is a child with a temporary period of residence. One of the things I always say, and Malti, I'm going to ask you about your experiences of entering the country, is there is a rule that once they admit you in green card status, they sort of waive their rights to object to certain things. So really a lot of this is about getting through the airport, getting through the border. And I'll just tell you, in many, many hundreds of EB-5s over almost a decade, we only had one client once who was from Chennai, who was questioned at San Francisco. And when I heard the account of what happened, he was actually rude to the immigration officer. And he literally said to him, "Do you know who I am? How dare you do this to me?" And, you know, those immigration officers are people that they're the last people on earth you probably want to have that attitude with. Many of them only have a high school education, and they're very proud of what they do in protecting America. So, you know, little bit of sort of cap in hand, "Thank you, sir. Yes, sir," it is a very good strategy. If they do stop and search you, which again, you know, I hear a lot of lawyers talk about this and I think cause unnecessary alarm. If they do stop you at the border, then just be, you know, sensible. They do have the right to search your cell phone. So when you come through the border, make sure that there's nothing on your cell phone that would suggest you're not resident in the United States. When they open your wallet, are they going to find Vietnamese, an Indian, or a foreign driver's license? Or are they going to find a US driver's license with your US address? Obviously, you want them to find the US driver's license with your US address. So one of the very important things is when you hit the border and preparing for when you hit the border. If we have a client who we deem to have some kind of risk, I suggest you talk to your immigration lawyer, because what we'll do is we will ask for the flight tickets and we will look at the airport of entry and we will figure out who the CBI supervisor is on the shift when that flight is landing. And then should the client, and it's never happened, have a problem, we can then reach out to the shift supervisor at the airport quite promptly and directly and hopefully resolve any questions. But as I said, it really, I don't want to raise alarm because it really hasn't happened to any of our clients. The most egregious one was actually my former partner. He got married in Chicago, he's Indian, and his aunt came in, and his aunt had a green card and she'd been in India for 3 years and not been in the United States. So we were certain that she was going to get questioned in Chicago for having abandoned her residency, but no, they just waved her in and said, "Welcome home, man." So, I don't recommend staying outside the country for 6 months. That's not the purpose of this story. The purpose of this story is to say the most important time is when you try to enter the country, really, and then perhaps at the naturalization stage. But in all the time, and some fairly egregious examples, none of our clients have ever had a problem. Malti, do you have any airport stories or entry to the US stories to share? Or has it just been plain sailing?
No, so far, I think it's 5 years I've been traveling up and down. I've been stopped twice for a secondary check. And first time when they stopped, I really had the trouble thinking that what are they going to do? But both the times I was stopped and then I was asked to go inside. They had a separate cabin thing like that and they called me there. And then the officer, there are a lot of people who are going for a secondary check. And I was one of them. Then when my turn came, the officer just asked me, "What are you carrying?" I said, "I'm carrying some laddus from India." And he said, "No problem, you can go." I don't know what is the reason for the secondary check, but both the times, I think maybe my baggage had something probably which triggered an alarm. Otherwise, I had absolutely smooth entry and exit so far. I never had any issue.
Which airports did you use? Have you used so far?
Generally, I use JFK or EWR. And I can call it a coincidence or I don't know, but JFK is the time, every time I've flown out of JFK, I was stopped. In EWR, I have never been stopped, never ever. And my number of travel is more in EWR than JFK.
I was about to say JFK is a great airport, but I won't now you've said that. But JFK for immigration, sometimes the problem is the immigration officers actually don't know the law and they have a training problem. JFK has a very good program where they can escalate questions and training for the officers, but obviously you didn't have a favorable experience with JFK, so it's there you go.
And I must tell you, last time when I was stopped, it was in Abu Dhabi.
Ah, there you go, Abu Dhabi.
Abu Dhabi.
Airports that people report problems with would include Miami. Miami always seems to come up. San Francisco, I've heard of several from San Francisco and Atlanta, the world's busiest airport. But again, I don't want to blow things out of proportion because Malti's never had a problem. None of our other clients have ever had a problem. That's hundreds of clients in almost a decade. No one's ever had a problem. So let's not worry too much. But, please, if they do stop you, let them find a state ID or a US state driver's license with your address in your wallet. And if it gets that far and not evidence that you don't really live here. Okay. How is the airport in Philadelphia? I used to go into Philadelphia and I think it's just, I haven't heard anything bad about about USCIS in Philadelphia. If that answers the question.
That's my question too, Mark. I am flying tonight out of Philadelphia.
I guess Philadelphia is a new place to go, right? um, okay, so, you know, maintaining residency is important. And also remember there's two different things going on here. One is maintaining your residency. And, you know, I'll say it again. We always recommend clients try not to be outside the United States for a period of exceeding 6 months. Even if you come back for 2 days, you know, don't be outside the United States for a period exceeding 6 months in a continuous block of time, because that's the flag. That's the way they're trained. We've heard this from a number of the CBP officers. They're trained to look, has this person been outside the United States for a continuous period exceeding 6 months? So, why trigger the flag? It doesn't make any sense. The other thing is, if you want to get a US passport, remember the naturalization rules. They're completely separate from maintaining residency. And for those who don't know, the naturalization rules are that in the 5 years immediately prior to your naturalization application, and you must hold your green card, conditional green card and full green card for 5 years to apply. In that 5 years prior to your application, have you spent half of that time in the United States? Now you can spend, you know, very little time for the first 2.5 years, and then a lot of time in the last 2.5 years and still qualify. But the rule here that you really want to remember is this: that 5 year period can get restarted if two different things happen. The first of those two things is if you spend more than 6 months outside the United States. If you do that, that 5 year period for naturalization presumptively restarts. What does presumptively restart mean? What presumptively restart means is they restart the 5 year period unless you can prove to them on inquiry that you really didn't intend to abandon your residency. And you look at the tax returns, you'd look at where your job is, they'd look at different things. Much easier just not to be out the country for a period exceeding 6 months. Re-entry permit won't help you with that. So all this nonsense with re-entry permits sometimes and how it helps you with naturalization is that nonsense. It's a completely different thing. Re-entry permit allows you to be outside the country, well, for a year, technically. That's from USCIS. Doesn't mean CBP are going to defer to it at the border. Furthermore, if you're coming back very frequently, you know, there's a question mark on that. It is an evidence of, it does give evidence that you didn't intend to abandon your residency, but I think far too much reliance is placed on re-entry permits. The second time that 5 year period resets is if you're outside the country for more than 1 year. If you're outside the United States for a continuous period of more than 1 year, that period resets and there's nothing you can do about it. There is a small exception for this, which is if you're working for certain very specialized organizations outside the United States, you can apply for a permission in advance to be outside the US before you leave. But most people are never going to qualify for that because of the institutions involved that you have to work for. So it's pretty much, if you're outside the United States for a year, that 5 year qualification period for naturalization is going to restart. If you're outside the United States for a period of 6 months or more, then that period would presumptively restart, but you can rebut that. Right, I'm just looking through these questions to see where we are. Don't have a US address, we've talked about that. Hi there, during my conditional green card period, my child will need to leave the US to Singapore for about 2 years where he reached 18 to 20 years old. This is due to mandatory military service in Singapore. But in between the 2 years, he can still apply for leave to return to the US for 1 week or so. What's the status? Well, we've had the Singapore thing before, and the problem can be with this is, you know, the attitude of the US government can be, well, you're supposed to be resident in the US. If you're a citizen of Singapore, that's different. But if you're just a resident of Singapore, it can cause a problem. And the reason it can cause a problem is they say, well, you're supposed to be resident in the United States, not in Singapore. We have a particular client. We have an office in Singapore and we have a lawyer in Singapore. And with a particular client, we actually went through a lot of planning on this particular question. They were actually gaining Singaporean citizenship, and they ended up doing that before they moved forward with the EB-5. But I think Singapore has some special flags and special questions when it pertains to military service, and really that's an individualized decision, but discussion. But generally, you know, if there's a very good reason why one of your children, if they're not the primary applicant, has to leave the United States for a period of time, then that is a circumstance in which to, I think, use that re-entry permit. And I wouldn't worry too much. We've had a lot of clients who have moved to America and left their children behind abroad. So for example, I had a client from Chennai who moved to the San Francisco Bay Area, but left his wife and 2 children behind in Chennai because they were finishing school. And against my advice, the wife and children stayed in Chennai for a whole year. After they got their green cards, and then they went back and they stayed there for a year and then came back to San Francisco, and they were just fine. No problems, no questions. So, you know, lawyers tend to be more conservative, but that can certainly be done. Lots of questions coming in. The problem is one job. One already has a job. So, you know, the United States is generally, see, here's one of the problems. There's lots of rules in US immigration, and then there's flexibility. So when you look at the whole sort of COVID thing, you know, if you are abroad, a US resident abroad during COVID, there may be some flexibility towards you. You know, theoretically, you want to get back every 6 months. You certainly don't want to be out for a year. But in the sort of COVID period, my experience is that the CBP at the border have demonstrated considerable leniency and flexibility. Now, they don't have to, and you can always get the wrong officer who you know, takes an objectionable position to these things. I'm just rereading this question. Yeah, so I think that the first year when you move to America, the US understands that you are, you know, in the process of settling, but they do intend that you need to be demonstrating that you are establishing residency in the United States. Having a job abroad is a big red flag. And if you have a child with a job abroad, then, you know, you need to call your immigration lawyer, or you're welcome to call us. We'll give you some free advice on it, and go through your individual circumstance and build a strategy and a plan to address and deal with that. Gary, we haven't heard from you from a bit. If I have children and they have foreign income, are there any taxation aspects to that to consider?
Well, you know, each individual is a separate taxpayer. So, you know, if, you know, each year, whether an individual has to file clearly for a resident return, if they have green cards or they reside in the United States, then it's only if their gross income exceeded a certain amount, say 15,000, whatever it is for the year, would they be required, you know, to file a return. But assuming you meet that, then you know, the special rules for minors, you know, depending on the age, if they're minors as opposed to adult, but the basic rule is that each individual is their own taxpayer.
Just to follow up, I'm going to answer another 2 questions after this. A lot of questions coming in. Marty, one of the people forwarded an email I sent to you talking about this issue of purchasing versus inheriting agricultural land, and an article from the Mint. I think you've had a chance to read it. Do you have any more comments?
Yeah, yes. See, the wording is best is to go to RBI. There is frequently asked questions are there. There the RBI clearly says that you cannot acquire. So the word acquire has different connotations. So some people interpret saying that acquiring means purchasing only. but it need not be true. Of course, it's individualized opinion. But in my opinion, acquire includes inheritance, gift, release, whatever form it takes. So generally, agricultural land, you have to be careful, because if you violate this law, the penalty is 3 times the value of the property. So therefore, it is better to go to the RBI and take permission and inherit, rather than to inherit based on that interpretation saying that acquire means only purchase. That's, in my opinion, is a very narrow interpretation.
Thanks for clearing that up, Monty. So Gary, back to you with a question, and then I'm going to ask you about bank accounts abroad and filing with the US Treasury, because I keep getting clients who don't know about that requirement. It's not well advertised, and the penalties are very significant, but it's free to comply. So, but here's the question first. If I have not filed Form 1040 NR for earlier years, can I file it now for the back years and claim a refund of tax deducted?
If there's a delinquent, well, first of all, we'd have to ascertain what your income tax status was for each year. You could file an amended return, for the prior years. There's a statute of limitations for filing a refund claim, which is like, in general, it could be 2 years. So we'd have to see on your facts if you're still within the limitation period. But, to avoid penalties for late filing, and if you owe tax for late payment of tax, we would have to study your facts and see if you could possibly qualify for one of the IRS amnesty programs based on your facts and circumstances, which would enable you to file for the back years, for the delinquent returns, and try to avoid the penalties and just pay the unpaid tax plus interest. But once again, that depends on your facts and circumstances.
So, here's a question which I think is quite simple. I have a K1 for 2018, 2019, 2020, 21. I don't, Gary, the question is not me. Since I invested in a regional center project, so obviously they're getting their interest coupon rate on their regional center investment. I haven't filed any returns for these years. So let's assume that the person is not yet a green card holder. There are things we might want to do to expedite that, but let's assume they're not a green card holder. Who can I engage to file my return and claim my refund?
Well, once again, you could engage, a CPA, United States CPA, to file, the back returns. You could always file an amended return to report the delinquent items, and you pay the unpaid tax and interest. The question is, can you avoid late filing and late payment penalties and accuracy penalties, which could be
but let's assume the person's living in India. They have no nexus to the United States whatsoever at all, other than they have this investment in the regional center that pays them a couple of $1,000s a year, which is way below the taxable threshold.
Right. There's a question whether, unlike if you were a resident of the United States and you were delinquent for filing for a given year, but you earned below the threshold for filing for that particular year, then there's no issue. We'd have to just double check if under the 1040 NR, there isn't any threshold. And even if you earn a relatively marginal amount, there was a tax filing responsibility, in which case, you'd have to file the back returns and see if you can avoid penalties through an amnesty program.
Right, but Gary, if someone's never set foot in the United States, they've never been to America, they just happen to have made this investment, they don't have a green card.
Well, you see, the thing is, the regional business center investment is viewed for United States tax purposes as an investment in a tax partnership for which you're getting a K1, right? So therefore, you're deemed to be engaged in trade or business in the United States because the RBC partnership is engaged in trade or business in the United States. So technically speaking, you're taxed on your distributive share of the partnership income or the interest, for that period. I mean, that's, that's an underlying tax obligation. And, if you were delinquent, it's a question whether to just file the amended returns or whether, to you know, see if maybe the 1040 NR has a threshold, or if not, then if there's an amnesty.
Okay, all right. So let's ask you, Marty. I think you do those kinds of filings, right? I think you file U.S. taxes for people.
Yes, yes, Mark. On this, I can say in my case also what happened, I had K1s from 2014 onwards. And I came to US in 2016. And when I came, I filed my back returns and I got my refund. So generally, because I had no connection to US, my incomes were so low and the K1s were below the taxable limits. And because of that, I got the entire money back, the entire refund. So the short answer for the question is that yes, you can get your taxes refund back, but I don't know whether he can file for 2018 now. There's a limitation, so we'll have to look at that and then tell. But yes, he will get a refund if he has no other income in US.
But you could help him take a look at his individual
Of course, yes. I
see
can
whether he can get the refund or not.
Yes, I can do that.
Gotcha, great. So, Marty, I'm going to ask both of you about foreign bank accounts filings, FBAR. You know, I was delinquent on my FBAR for 2019, and I just sorted it out with Gary's help. It was just a nightmare for lots of reasons, but a lot of people don't know about this. So Marty, I assume you do know about this. Can you explain what it is, why it's important? And then, you know, if you can, you know, Gary, please chip in. It would be wonderful if the two of you had a conversation about this.
Okay, can I go first?
Yeah.
Go right ahead.
Okay, so essentially FBAR is foreign bank account reporting. So the genesis for this is that US realized sometime before that there are a lot of people who are not reporting their income globally, which they are required to report because of their residency or because of the citizenship. So they brought in this, what is known as the FBAR. FBAR filing is due with your tax returns. If your tax returns gets extended, the FBAR also gets extended. In essence, the FBAR requires you to report every bank account you held anywhere in the world. So you can hold bank account in 2-3 capacities. One, you can hold in your own name, so which you have to report. There is no doubt on that. Second one, it could be joint with your brother, sister, partner, firm, whatever that you need to report. The third one is where you have an authority. You just have an authority. And this authority, I want to clarify here, when they say you have an authority, regardless of the fact, whether you signed the checks, whether you operated the bank account, you need to report just because you had an authority. And if you don't file, the penalties are $10,000 or 25%, and it is linked to the inflation. So as of now, if you don't file your FBAR, the minimum penalties you would be paying is about $12,000. So the penalties are very high. And in the recent past, I have seen this IRS has been very strict on these FBAR filings. In fact, they are taking they look at your returns for last 2-3 years and then issuing notices saying that whether you have filed or not filed. So FBAR is very, very important for everyone to file, regardless of, and of course, the important threshold is that it has to be more than $10,000. If your foreign bank account balance at any time during the year is less than $10,000, then it doesn't require filing. But if it is more than $10,000, it requires filing.
Gary, so let's just go over when does my liability to file FBAR start? Let's suppose I have a non-immigrant visa, no green card, and I'm working in America versus having a conditional green card. Is there any difference? When does it trigger the liability to file an FBAR? And then let's suppose I didn't know about this and I've just found out that I owe them 4 years of returns. What are the penalties, and is there any way around it?
Yeah. What was the first question again?
My first question is, when does it trigger? If I'm on an E2 visa and I'm only spending 3 months in a year directing and controlling my business in America, and I don't really have a tax presence in America, am I responsible for FBAR? Versus if I'm a conditional green card holder, do I have to file FBAR, and when does it trigger?
Okay. One of the things I review with my clients is that what changes when your tax status becomes resident from non-resident to the United States. There are a lot of ramifications. We said before, taxed on your worldwide income, but equally important is your tax reporting obligations, which includes an FBAR. So once you become a tax resident by green card, provisional or temporary or permanent green card or presence or a citizen, then you have the foreign bank account reporting obligation. Now, as Mr. Malti said, this is taken very seriously by the United States. It's not, there's no tax due, it's just information reporting. But if you're delinquent, there's a 6-year statute of limitations. They could go back 6 years and assess penalties of $10,000 per account per year, going back 6 years, as penalties. Now, if you were delinquent, there are several amnesty programs where if you can explain what the mindset was, what the facts and circumstances were, and show that it wasn't intentional, whatever, and then prepare the relevant reasonable cause statement, or there's a very favorable amnesty program which entails certain analysis, and we do that electronically. Then you can file to delinquent FBARs for the back 6 years and avoid all penalties, which, as we see, could be significant. So once again, it's it's your facts and circumstances. We make a determination: are you qualified? Which of the favorable amnesty programs you can qualify for, and then become. But the important thing is to do this before the IRS finds out, because once the IRS, if they were to find out before you were making a voluntary disclosure, then it's much harder to waive the penalties. So those are important points. Other things to note is that it's not just bank accounts. We have to go over with the client an inventory of all their foreign financial assets outside the United States, because under certain circumstances, life insurance, or pension plans, or Social Security, or mutual funds, or brokerage account, whatever, you want to file an FBAR that's all-embracing, that's thorough and comprehensive, and that it doesn't leave anything out, because as we see, delinquency or whatever, can be very costly.
So Gary, here's a question on FBARs. The person is saying, I have filed FBARs when I was a US tax resident, but I haven't in the last couple of years, as I am no longer in the US. Now, when he says I'm no longer in the US, he's not saying whether he's gone through the process of surrendering his tax residency as opposed to his immigration residency. So we don't know. If he wants to tell us that, he can do, and we can give some better analysis probably. But so I have filed FBARs when I was a US tax resident, but I haven't been for the last couple of years, as I'm no longer in the US. I just would challenge, I'm no longer in the US, therefore I'm not a tax resident. You may have a nasty surprise. But Gary can speak to that. But assume the requirement is, and then he says, I assume the requirement is only applicable for residents.
You see, Mark, you're raising a very interesting point. We've had cases working with Mark's clients over the years that clients don't realize that, notwithstanding that immigration law and tax law are brother, sister, they're separate and distinct. They're independent. And so technically speaking, Mark could determine that a particular individual, his green card lapsed and whatever, and for immigration purposes, he's no longer deemed to be a green card holder. Notwithstanding that, the tax law operates with a fiction, that if you did not relinquish the green card in a certain prescribed manner under IRS regulations, and then filed certain information returns and everything like that, you're deemed to continue to have a US tax resident, notwithstanding that you're outside the United States the entire year. And if you were delinquent, and we've had cases like this before, and we were able to get them through important amnesty programs and with important narratives, et cetera, to demonstrate to the IRS what the mindset here was. It was innocence, good faith, et cetera, and that we were able to go back and file the delinquent FBARs, for the 6-year period and avoid penalties for the individual.
Okay, so his follow-up question is, sorry for the clarification. I am not currently a US tax resident, but I've had to file a 1040 NR once.
Well, once again, if you were a 1040 NR filer and your tax status for US tax purposes under domestic tax law was that of a non-resident, then the FBAR doesn't apply. doesn't apply to you. It's just if you were a tax resident for tax purposes, separate and apart from immigration. We have to see if you meet the requirements as a tax resident.
Now, Gary, what if you're a U.S. citizen?
Oh, well then you're clearly a U.S. resident, and therefore this would clearly apply to you, notwithstanding that you're outside the United States all year.
Okay, so that's a downside of being a U.S. citizen. You're going to be tied to FBAR for the rest of your life, or as long as you maintain the U.S. citizenship, right?
Yeah, but you're raising a good point for a green card also. They're on the same standing that you could be outside the United States. And we've had cases like that, and we had to get them through very important amnesty programs because there were very high penalties that could be assessed for that.
So once you get a green card, if you're maintaining your green card, it doesn't matter where you live. If you're maintaining your green card, you have an FBAR responsibility.
That's a very very important point that a lot of people don't realize. We had a lot of cases because of that, and as long as you meet the tax requirements for residency, notwithstanding you're outside the whole year, and notwithstanding that for immigration purposes it's no longer valid, there's a fiction here, and people get caught in that trap, and we have to help them out. You know, we've done that together in the past with quite a few clients to get them out of penalties.
Yeah, I think it's I got to say, I think it's really wrong that the U.S. government don't publicize the obligations of FBAR more clearly, because they don't. And unless someone tells you about it, big chance of you not finding out about it. And I just think to then penalize people is just wrong. But, you know, hey, that's the way the system works.
No, that's why I just want to say, Mark and I always stress we have to get a snapshot of your global assets, because as we said, it's not just bank accounts. If you're delinquent because you left out funds or pension, you know, whatever, you're likewise caught.
More questions coming in. We're going to answer them all. And, you know, as I said, there will be a tip sheet of not just tax, but maintaining your residency with some things we haven't talked about on this. But I'm going to go back to Malti because of a question being asked. And here's the question, Mr. Malti. You know, remember, Malti is a very well-known tax accountant in Bangalore. I've been to his office. Many people in the city of Bangalore know Mr. Malti and his multi-story tax building there in central Bangalore. Anyway, the question is, I have invested in a regional center, received income of $450, $1,000 less the tax deduction. I'm still in India. What is the tax filing return obligation in India as well as in the USA?
Okay, Mark, I'll take the question, and it is for India. It is liable for tax in India because I presume he's a resident in India. So if he's resident in India, he's liable for all the taxes. So the entire $1,000 is liable for tax in India. And when it comes to US, I think if he has no other income in US, then he'll be able to get that refund of $550 by filing 1040 NR.
So you're saying what he needs to do is file a 1040 NR, get the $550 taxes he's paid in America refunded, and then you'll have to pay tax on the entire $1,000 in India. Is that your advice?
Correct. And he'll be entitled to claim that foreign tax credit if he doesn't file the tax return. But if he files the tax return and takes the income that the tax deducted as a refund, then he'll not be able to claim the foreign tax credit because he has not paid any tax.
Got it. Okay. So if he doesn't get the US tax refund, he can claim a credit for the amount of taxes he's paid in the United States on his Indian tax return.
Correct.
Okay, thank you. Let's see, so many questions still coming in. How can I maintain a green card while staying outside the United States most of the time and avoid the US domicile for US tax, capital gains tax, and gift tax purposes? You've lived this personally, Malti, so. Do you hear the question?
No, I got the question. So the short answer is it is not possible because once you are a US person, the wording they use is a US person, which includes the resident aliens, then green card holders and citizens. So once they are maintaining the status of green card, probably it is difficult. But there are certain ways which we can discuss, not in this forum. Maybe when he has a specific thing, we can discuss and then try and minimize that, if not completely eradicate.
Being a conditional resident and claiming, or any kind of resident and claiming, you have to be very careful with claiming non-resident tax status. That could be a recipe for the loss of your green card, especially if you're in the conditional status. So, you know, we won't get into the intricacies of how those things can work together, because it's just way beyond the level of depth we can go into. But just be very, very careful of doing that. You know, there are people who have lost their green card because they've tried to claim non-US presence in their tax return. Okay, right. Let's see, what else do we have here? I continue with my question. Okay, more from the same questioner, Malti. I continue with my question. $1,000 of US dollar income. I am still in India. Am I required to file a US tax return?
Okay, he is not required to file, but if he files, he'll get his refund. But if he doesn't file, nothing happens, because he has no income that is liable for tax. Of course, the $1,000 is liable for tax, but he has already paid tax on that. So the tax which they have withheld is much more than what his tax liability will be. In my opinion, his tax liability is zero, because if he doesn't have any other income, the tax liability is zero, and he has paid excess tax to the government, US government, so he'll be fine.
Somebody is asking for your contact information, Marty. So, you know,
Yeah,
we'll
you
send
can share
out your details afterwards, but no problem. But you know, just so you're aware. Right, that's that question dealt with. Okay. Let's see. How can I maintain a green card by 6 years while staying? How can I maintain a US green card for 5 to 6 years while staying most of the time? Gary, let's ask you on this. How can I maintain a US green card for 5 to 6 years while staying most of the time outside the United States? And the purpose of staying outside the United States is to avoid US taxes and to give green card to children.
Well, once again, if for tax purposes, you know, the green card is still alive, albeit by a fiction, you know, and you haven't taken the relevant steps to renounce the green card for U.S. tax purposes, even if you spend all your time outside the United States, you know, you know, all the rules attached to being tax resident apply, including tax reporting and income tax filing. You would have to renounce the green card according to prescribed procedures, go through that whole process, which we've done a lot together, and then you'd be out from a tax resident status.
You are taking a very high. I think, you know, what this might be is somebody has a green card as the primary applicant, and then they have derivatives, and derivatives perhaps in America, and the primary applicants in India. You are taking a very, or another country, doesn't say India. You're taking a very big risk. You know, you're supposed to be, when you do have a green card, you're supposed to be primarily resident in the United States. So if this gets questioned, you know, not only you can use your green card, but all of your dependents will too. So Marty, do you have any comments on this one?
Yeah, there is a way. One thing which I would like to say is that every US person, whether he's a citizen or a resident, can claim foreign exclusion, foreign income exclusion. But the condition is that he has to stay outside US 330 days, and that has an income restriction. That means not the entire income can be claimed. I think, if I'm not mistaken, that amount will be $110,000 or $120,000 per annum. You can claim foreign exclusion and don't pay taxes in US.
No, but I believe you have to file the form 2555 to affirmatively claim that.
Correct. You're right. There's a form that was filled, and sometimes recently I had a case to deal with, which is exactly what the question has been asked. But I found out that claiming foreign exclusion was detrimental to his tax returns. He would have ended up paying more tax if he had claimed foreign income exclusion. So the claiming FTC was more favorable to him. So we filed without claiming that. It is the option which you can exercise.
But I mean, you are putting yourself at real risk for loss of your green card if that's really what's going on. you know, if they, you really are. I mean, you need to consider this very carefully in your physical presence in the United States and look at sort of absences of 6 months, but you know, to continuously be outside the US and file a non-resident tax return is really a, you know, when you come to the I-829, if you're on EB-5, that's a real red light sometimes for them. Certainly when you get to naturalization, you know, they actively look at those issues. So, you know, just be aware of that. Right. So here's a question, another one. Do you have suggestions for a retired family moving to the United States on a green card with children going to college in the US? Gary.
Well, you know, there's a lot there. I mean, you know, there are income tax, there are transfer tax. You know, while you're still a non-resident, as I said, for income tax, you know, first of all, if you were to buy a home in the United States while you're non-resident, to avoid estate tax, because it's a U.S.-based real property, there are tax planning strategies I could work with you on to acquire the home in a tax-efficient manner. While you're non-resident, there's family succession planning we can do to try to avoid estate tax on significant assets, you know, upon you know, the first spouse's passing and the second spouse, and perhaps we can actually provide for family succession that to avoid federal estate tax and the GST generation skipping tax for future generations. So we would have to analyze your global assets, if you have excess cash, the nature of your properties, what your objectives are. So all of that planning would be done before you leave India, you know, to come to the United States. That's from a transfer tax standpoint. And as I said, from an income tax standpoint, while you're still non-resident, you know, if you wanted to purchase a home here, we structure the purchase in a tax-efficient manner and work with you on maybe certain capital gains transactions or reorganizing your assets abroad. So when you come into the United States and become a resident, the tax bite will be less adverse.
And obviously, Gary, you know, people can do estate planning too, right? It's easier when the people are abroad to look
Yes.
at trusts and different things whereby,
Right.
you know, they can move their money to their children in a much more tax efficient manner than after they've become a US resident.
Yeah, that's a critical point. As we said before, there's a window of opportunity here. And what people don't realize, it's not just income tax. The federal estate tax is 40% of the fair market value of property that's passed upon your passing. And then there could be a generation skipping tax too. And under the Biden administration, they might increase that to 45%. So when you're still a non-resident and the US tax jurisdiction is more limited, exactly as Mark said, it would be propitious to do this tax planning, not just from an income tax standpoint, but a transfer tax standpoint.
And a related question, that the first one that came, is there inheritance tax in the USA?
Well, from a federal standpoint, usually inheritance tax connotes that the receiver, the heir, is taxed on it. In the United States, it's an estate tax. It's a transfer tax. It's a tax imposed on the transfer of property at death, right? Just like the gift tax, the sister to the estate tax, is a transfer tax on the transfer of tax of property by gift during one's lifetime. Both of them are subject to the 40%. You know, some states, in addition to the federal government, they have their own, some will have an estate tax, some call it, as you say, an inheritance tax that the heir pass, it's on the heir. Others, like New York, California, it's on the transfer of property, it's on the transferor. The estate of the deceased person is liable for the tax.
Right. So, you know, there is inheritance tax in the US, but tax planning, I think, is essential. There are, you know, first of all, Gary, you know, you might explain what the sort of exemption is on inheritance tax. You know, that's sort of good news. And then even if you exceed that exemption,
Right.
you know, there's ways to avoid it, legally avoid it, right?
See, Mark is making a very good point. Remember we said before that there's, from an income tax standpoint, what's the difference between non-resident to becoming resident? And to mitigate that, it's advanced planning on a proactive basis while you're still a non-resident. The same thing is when you're, with respect to transfer taxes, the federal estate tax. What changes when you're a non-resident to when you become a resident, and on your passing, your estate is liable for worldwide. Your worldwide assets are subject to this 40 or 45% estate tax. Now, under existing law, the first 11 million plus of assets that you transferred at death plus lifetime is not subject to federal estate tax. But as Mark said, the excess of fair market value of the global assets over that is subject to federal estate at 40, 45%. That's why planning is so important, especially as Mark said.
That might be interesting. It might be interesting to just ask Marty quickly. Marty, is there inheritance tax in India? And if so, is there an exemption, and what is it?
No, India doesn't have inheritance tax. It was there earlier, probably in 1985, 86, called estate tax. So they removed it, but there is a very strong rumor that they may reimpose. But we don't know. So far, we don't have, luckily.
But if they do, would you expect to see an exemption as big as $11 million?
No, I don't see that. I don't see that. No.
Correct. So I'm just thinking that under this circumstance, for the right client, it may actually be advantageous to have it passing under the U.S. tax regime, where you get an $11 million deduction, right?
Now, the only thing I want to add is that the Biden administration is in the process of designing tax proposals, changes to existing tax law, and one of the things that they're looking at is exactly what Mark said, to lower this exemption from 11 million to something like 3 to 5 million. So that's something we're monitoring.
Can your U.S. address for filing taxes be a home that you own but have leased or rented to a third party?
Can you please repeat that question?
Can your U.S. address for filing taxes be a home that you own but have leased or rented to a third party? In other words, you're claiming to live at an address that you actually don't live at all because the property's been leased or rented to somebody else. So let's say I have a home in Florida, Gary, which has zero state income tax, and I've rented it out. I actually don't live in the state of Florida. I live somewhere else differently. But because it's so tax advantageous in Florida, I tell the government, well, I live in Florida in this house, and I file my tax return in a Florida tax return, but I actually don't at all because it's rented out.
Yeah, I mean, you really have to be very, very careful, because, you're filing these things under penalties of perjury. And you don't want to be perceived by the IRS as engaging in tax evasion or fraud. I mean, you really want the return to reflect the actual facts, and that whatever statements or representations you're making on the return comport with what the objective facts are.
So if you declare an address on your tax return, you're declaring that you live there, correct?
Yeah, unless you're putting a CO, a care of address, with your attorney or your CPA. It depends how you answer that question on the front of the return.
Right, but certainly if I'm filing like a Florida state tax return with zero income tax and I don't really live there, I actually live in New York, that's a big problem, right?
Oh, that would be a big from 2 states, because you're trying to avoid a New York state tax, evade, and then it's not correct it's an inaccurate return.
Right, tax fraud. Right, just looking down, a few more questions. We've been going an hour and a half, so I'm going to wrap it up, but you've answered that question. When one moves to the United States, the funds earned somewhere else will be transferred to my new account in the US. Is there a limit to the amount we can bring in? And should you have to produce proof of income to the tax authorities when you bring in that amount of money to US account? So in other words, let's say I've got a lot of money sitting in India. I get my US green card and I want to move $500 billion to the United States. Can I just do that? Or they're sort of, well, I think if you tried to move $500 billion, they would get noticed by somebody, but let's say a lesser amount of money, lesser amount of wealth, you want to move to the United States.
Well, you have the Patriot Act, so separate and apart from tax, your banking regulations, to see that it's not money laundering, so you have to, satisfy all of that. From a tax standpoint, and Mr. Malti, you can express also, as long as if it were a gift, if these are funds coming from your parent who's living in India, and you become a U.S. person, well, at the time that you receive the gift, then you would have to, the recipient would have to declare that. But that's only if, a resident, at that time.
So Marty, if I'm moving a lot of money out of India, other than FEMA, which I think everybody's aware of, though I guess you could re-mention it, are there any sort of expatriation considerations or exit tax considerations from India?
No, not. Only thing is they introduced a new law from last year where they said if you're doing an LRS, there is some withholding of tax on such amounts which are remitted out of India. Other than that, more or less everything remains same. And I think his question, what you're asking, there is no limit as far as the US goes. When the money comes to US bank account, there is no limit. But definitely he has to maintain the proof of what that money is. If it is established it is income, he is liable to pay tax. So he has to have enough evidence to prove that it is not his income.
Okay, all right. Here's what I'll slip in one more question. The questions are still piling in, but we've been an hour and a half. I-526 is pending for the last 2.5 years, and staying outside the US is a minimum income of $400 to $500, gets yearly from regional center, gets tax documents from RC, filed US tax return and applied for ITIN 6 months before, but not a single word from the US tax authority. What options do I have? So he's outside the US. He doesn't have his green card because his I-526 is pending. He's getting the minimal interest income from the regional center. Sounds like he's saying he's filed his ITIN 6 months ago, but he doesn't have an ITIN yet. So what should he do?
Well, he has to report on the 1040 NR, right? But he doesn't have, so, sometimes if you write on the ITIN on the address, there's a line there on the first page, and they ask for your ITIN, a social security number, you can just say applied for, or, try to give proof that you're waiting to hear back.
Barry, let me ask you a question. I mean, we frequently apply for tax numbers for corporations that clients are setting up in America, and they come very, very fast. The US government seems to be the only entity using fax anymore in the whole world, but regardless, they'll come in by fax and different means. They come very, very quickly. If he's been waiting 6 months for an ITIN, is it quickest just to apply for another one, or is there, what's the right procedure?
See, the thing is, Mr. Balti, I'm interested in your experience. I'm working on some parallel applications we made with the Social Security Administration in the United States, and because of COVID, and people aren't coming to the office, the huge delays in hearing back. We made an application 3 months ago. It's a very important matter, and we haven't heard back. And they said they're just overloaded. Backlogged, with cases, and people are working from home. So, there are a lot of delays, and I would just make a note of that it's applied for here. Lots of times when you make an application, you get a case number or a control number, so they could verify that it's in the process of being reviewed.
Mr. Malti?
Yeah, I would wait for some more time and then I would reapply for ITIN. Perhaps it is got misplaced, which happens sometimes. Generally, I see they're very quick in allotting these ITIN numbers and others. But if he has not got it for 6 months, probably his application is misplaced. So I would give some time for COVID. Otherwise, I would reapply.
Okay, all right, sir. Well, thank you very much to everybody. And, we've been going a very long time. So thank you to Gary and thank you to Mr. Malti. And, if you have any questions on this topic, please don't hesitate to email us or reach out, and, we will endeavor to give you an individual solution. So with that said, thank you very much. Bye-bye.
Thanks, everyone. Bye-bye.
Thank you.